Good morning, everyone. My name is Teresa Satfin, and I'm with the Area Agency on Aging. We want to welcome you to the last in a series of our educational workshops, virtual education workshops. We want to thank Hillview Healthcare and Rehab for sponsoring today's program. And I want to introduce our speaker. She's going to talk about planning and preparing for aging. Her name is Amanda Pettry. She serves as the Deputy Director of Litigation and Advocacy at Legal Aid of East Tennessee in the Johnson City office. She received her bachelor's degree in accounting from Auburn University and obtained a Juris Doctor degree from Cumberland School of Law, Sanford University. I apologize. I'm going to turn it over now to Amanda. Thank you all for participating.
Thank you, Teresa. Good morning, everybody. Welcome. I'm going to share my screen here. Let's see how I can get this. All right. Believe everybody can, everybody can see that. So as Teresa said, my name is Amanda Pettry. I am an attorney here in the Johnson City office. I am also one of the attorneys for TESSA. And so TESSA, we will go on to the next screen. Just a short little snippet, Legal Aid of East Tennessee. We are a nonprofit law firm. We provide free legal services to low-income individuals. We do serve 26 counties in East Tennessee. We have offices all the way from Chattanooga all the way up to Johnson City, where I'm located. Specific hard offices are in Knoxville, Maryville, Chattanooga, Cleveland, and Johnson City and Morristown. We do have family justice centers also that are located throughout our service area. We practice only in civil matters, so we do civil legal services ranging from information and advice to complex litigation and appellate advocacy. Typically, right now especially, we predominantly are providing services with regards to housing, family law, consumer law. We are doing a lot of estate documents. Especially right now with the pandemic going on. I think it's made a lot of people think about preparing and planning for the future and getting their affairs in order. So we have had a pretty big uptick in those matters. We do not handle any criminal cases nor fee generating cases. And I have put our website up on the screen for further information on that. So what I was mentioning before, TESSA. So TESSA is an acronym for Tennessee Senior Law Alliance. It is a collaboration among legal organizations that are dedicated to serving the growing senior population by providing lasting local impact for vulnerable seniors in all 95 counties in Tennessee. It's exceptional. It's wonderful. It's a great project that was funded by a grant awarded through Davidson County Chancery Court. It was a case there, and that settlement resulted in this project being able to be funded, and it's also funded through a contract that's administered by the Tennessee Commission on Aging. It does allow us to provide long-term solutions, specifically regarding how to sustain and improve the quality of life for our elderly individuals. If a person qualifies for help, as I previously stated, the legal services that we provide are completely free, but that is only our legal representation. Just because we are a nonprofit, the client does have to pay for filing fees or other fees that may be assessed by a third party for these matters. You know, a lot of times there are ways for us to have those filing fees waived, depending on the situation, specifically depending on the income of the client. We may be permitted to file an affidavit of indigency or something of that nature to allow those filing fees to be waived or postponed to a later date. Eligibility requirements for this TESSA grant that I have mentioned, the individual must be over 60. They must be a citizen or legal resident of the United States, and they must reside in one of the counties of our respective service areas. If they don't reside in a county, in our county specifically, we do work collaboratively with other legal aids across our state of Tennessee, but also across other surrounding states. So we can make direct referrals to those states, so that way the individual can receive the services that they need. As I stated, the goal with TESSA and just with legal aid in general, we want to improve the quality of life for our seniors. We do, like I said before, we do a lot of, especially for our seniors, we're doing a lot of consumer cases, which are debt and bankruptcy. We do a lot of housing, especially right now. Unfortunately, I personally have seen a lot of seniors being subjected to evictions, here in East Tennessee, which is just very heart-wrenching, because especially with their age, and most of them are on a fixed income, very low income, their ability to obtain alternate housing is a lot more impeded than other individuals. But we have seen an uptick in that. We do represent those clients in court on those eviction matters. And then we also, as I said, we do a lot of estate planning, which is predominantly what we will be talking about today. So first, I've got estate documents. So the specific estate documents that we'll be discussing today are wills, a durable power of attorney. We say durable power of attorney, and for us, that just means a power of attorney over an individual's finances, property. The way that I always describe that one to people is it allows somebody to step into your shoes to make decisions for you, so they can apply for benefits for you if need be. They can execute other powers of attorney if needed. For example, I also do IRS matters for not just seniors, but for individuals who qualify for legal aid services. So with the IRS, you have to have an extra power of attorney done that's specific to them. It's called a Form 2848. And so that durable power of attorney would allow me to execute another power of attorney, or allow that individual's agent to execute another power of attorney to appoint me to help them with that matter. So it's a very, very broad power of attorney, the durable power of attorney is. The next one is an advanced care plan. We like to call that as the living will. And then the last one is the appointment of a healthcare agent or power of attorney for healthcare. And we're going to go into each one of those. So first is what is a will? A will is a written document that contains your wishes for who receives your property after your death. I like to say that the will does not speak until you die. So it's unlike your power of attorneys, which are effective and speak now while you are living. The will only takes effect when you die. That's good for several reasons. One, it can be changed by a subsequent written document at any time prior to your death. So if you had a will drawn up, you execute a new will, that new will revoke any previously executed will. I have amended many wills over the years, and because a lot of times circumstances change, life happens, people unfortunately families may dissolve, and so they need to update their will to correctly list their wishes for who is to receive their property and to update what property they have. So just general requirements, a will must be in writing. There is an exception to that writing requirement. It's what we call a holographic will. I won't get into holographic wills in much detail. They're not a preferred mechanism for a will, because if you can get a will in writing, signed, dated, and notarized and witnessed by two people, that's a more solid route to go. You have a much better chance of it holding up in court if it is litigated or disputed. With the holographic will, one interesting requirement is that the entire will must be in the testator's handwriting. So there can't be part in the testator's handwriting, and the testator is just the individual who's writing the will or drafting the will. It must be fully in their handwriting, written out. It can be on notebook paper, it doesn't matter, but it needs to be witnessed and then signed and dated. It doesn't have to be notarized. But one big thing, one reason that the holographic will isn't usually preferred is, it would require after their death, somebody's got to attest to, that is the testator's handwriting, in fact. So those matters can just become a lot more litigious, versus if you go your traditional route with having a will in writing, signed, dated, notarized, witnessed by two people. It's just a lot easier. Benefits of having a will. The main reason that I recommend people to have a will is that you get to choose what happens to your property upon your death. You also get to name the person as to who you want to be executor. The executor is merely the individual who is the one that carries out your wishes. So they're the one that, if your will goes through probate, they're the one that presents the will to the court. They will become administrator of the estate. They basically dot all the I's, cross all the T's. They make sure that your wishes are honored, that the people who you've listed in the will to receive certain items of property, they're the ones that make sure that those parcels of property are received by the intended recipient. One thing I've heard it a lot is that, people say, well, I don't really have much, so I don't think I need a will. I think that everyone should have a will personally. I think that there's, even if you don't think that, or you're, the individual that you're assisting, even if they think that they don't need one because they don't have a lot of property, I still think it's good to have one, especially in situations where there are blended families, and especially in situations where, maybe there's been a divorce, or a remarriage, or a lot of times, especially lately, I've seen where people will get divorced, but continue to cohabitate together. And so, they, but for all intents and purposes, want that the individual, mainly their ex-spouse, the one that they're cohabitating with, they want them to receive everything, upon their death. But if they don't have a will, then the law does not presume that ex-spouse would receive anything. And so it's a way to ensure, that the people who you want to receive your property upon your death do in fact receive it. Another big thing, that a lot of questions that we've received lately in my office, is wills and with regards to like real property versus personal property. It's come up a lot. And when it comes to, one interesting thing, when it comes to real property versus personal property, real property, depending on how the deed to that property is drafted, that real property can actually pass outside of the will. It can pass outside of probate, depending on the language that's contained within the deed, to where the will does not touch that deed. The will does not touch that property. And so a lot of people prefer to ensure that specifically their land or homes, their real property will go to an intended recipient that way versus having a will, because that's generally the most the largest item of property that they have, that they want to make sure a specific individual does receive that property. Next, what happens if you don't have a will? So if you don't have a will, your property will be distributed according to the state statute in which you were domiciled. So that just domiciled is a fancy term for where you are physically located with the intent to remain indefinitely. So for most residents within the state of Tennessee, it's, their property will be distributed according to the state of Tennessee if this is the state in which they are domiciled. So it's where they reside with the intent to remain indefinitely, then our laws would govern here. One common misconception that we come across is a lot of people seem to presume or think that their spouse, if they are married, will automatically receive everything that they have if they pass. So if they think that if they don't have a will, oh, well, I'm married, my spouse will receive everything. That is not necessarily the case. Specifically, if you die without a will and you are married and you have children, then your spouse and children will both receive part of your estate. Your spouse will not receive the entire estate, which is generally what people want. They most of the time with those types of wills, people will want their will drafted to where, upon their death, their spouse receives everything, and then if their spouse should predecease them or die before them, then they want everything to go to their children equally. That's probably the common will that we do in those types of situations. But unfortunately, like I said, if you pass without a will and you are married with children, your spouse will not automatically receive everything. It's actually a percentage. The court goes by a percentage, and that's called intestate succession. Additionally, if you die without a will, the court will decide who is the executor of your estate, and they may appoint the public administrator. That, if it's an uncontested probate matter, a lot of times the court will give deference to who, if there's a family member that's willing to serve as executive of the estate or administrator of the estate, then the court will appoint a family member a lot of times. But, that's just to say the individual who has passed, they don't get to pick who it is. It's a lot longer of a process because you have to petition the court for an executor to be appointed and then wait for the court to do that. Additionally, and this is another big thing that I hear lately is, it doesn't matter what you've told somebody you wanted, your wishes must be in writing, or else, like I said, the laws of the state of Tennessee will govern. They will dictate what happens. Unfortunately, I've seen that a lot lately with, especially situations where people cohabitate. They are not married, they are not family. And I'll have somebody contact the office to say, well, they always told me that they wanted me to receive, whether it be a vehicle, or they wanted me to continue to live in this mobile home, even after they passed. And it's always hard to tell, well, unfortunately, if they never put that in writing, never put you on the title, never added you to the deed, I never had a will drafted, that the individual who passed, their family can step in and take that property right out from under you. And so that's always a hard conversation to have with people, which is just another reason, like I said, I really recommend that everyone have a will drafted. Next is the durable power of attorney. So like I said, this is the power of attorney that I said is very broad. It grants very, very broad authority to the individual or agent that you appoint to serve as your power of attorney. It does allow you, like I said, to appoint a specific individual or agent to take care of your financial affairs and other personal business affairs in the event that you are not able to do so. There are two different ways to have a power of attorney drafted, the durable power of attorney. One is that it becomes, in the most common way, I will say that, is that it becomes effective the moment that it is signed. And so, we draft it, it's signed, dated, notarized. At that point, the power of attorney is effective. So whoever you have appointed to be your power of attorney, at that moment, it's signed, dated, and notarized. They can act in that capacity for you. They can sign other documents for you. They can go to the bank for you. They can buy and sell property. Like I said, they can help you with any types of applications, handle business affairs, whether it be with insurance companies or anything like that. They are able to do that immediately upon execution of that document. One big thing, that document must be executed while you are still competent. So if the individual or you are not competent to sign over power of attorney to someone, then this would not be not be possible. Instead, you would have to have a conservator appointed. Now, it can be used while you are competent or incompetent. So typically, when these are drafted, we always have a provision contained within it that says that the document will remain effective despite any subsequent incapacity. So just because you say, for example, you've executed your document, you're competent, you sign, date, notarize it, it's good, it's effective. Well, just because you become incompetent down the road, that document is still effective. The individual can still act as your power of attorney despite that subsequent incapacity. So that's one big, the power of attorney is another big one for people to go ahead and execute now. I've seen a lot of situations, especially here with the pandemic. Unfortunately, people end up in the hospital. They're on a ventilator, or just something happens. They're in a, heaven forbid, they're in a car accident, and they never executed a power of attorney. Well, they can't have one executed now, and so they have to go the conservatorship route, which is a lot more. The process to obtain conservatorship is a lot more lengthy. It's not nearly as cost efficient or as quick to have it finished. So the durable power of attorney, like I said, is another big one that people should do in preparing and planning for the future for aging. Another way to have a power of attorney drafted and executed is you can, and I have done this several times as well, is that the power of attorney, instead of becoming effective at the moment it is executed, so like we said before, the moment it's signed, dated, and notarized, instead of it becoming effective at that point, we can draft the document to where it's called a springing power of attorney, to where it would not become effective until the individual becomes incapacitated or incompetent. A lot of people prefer that just because it does allow them to retain that autonomy and independence now. And so they wish for it to be a springing power of attorney, to where once a licensed physician has declared them incompetent, at that point, that durable power of attorney would kick in. It would become effective. So the individual that was listed on there as the agent will then be able to act in that capacity to make decisions for the individual and to assist them in handling their financial affairs or other personal business affairs. Because at that point, they're no longer able to do so due to that incompetency that's been determined by that licensed physician. So like I said, that's another way to draft it that a lot of people, or some people, prefer, just because they do want to hold on to that independence, but at the same time they want to prepare and plan for their future. So I touched on this a little bit already, what happens if you don't have a durable power of attorney. So like I said before, if you become unable to make decisions for yourself, or you're not competent to sign legal documents, then a conservator would need to be appointed by the court. The appointment of a conservator does require a lawsuit to be filed. So someone has to petition the court for that conservatorship. It requires a guardian ad litem to be appointed. There's filing fees associated with it. That's why we say it can be expensive and time consuming, because in addition to just the petition being drafted and filed, court costs to be paid, the guardian ad litem has to do their assessment of the individual who's going to be declared incompetent, so that the guardian ad litem is actually that individual's attorney, and there are costs associated with that, as well, that guardian ad litem being appointed by the court. And you have to have physician sworn statements to accompany the petition. And so it's a more lengthy process. And a lot of times, unfortunately, when that appointment of a conservator is needed, it's needed almost immediately. And so that's why it's much, much more beneficial for someone to go ahead and plan and prepare for their future and have that durable power of attorney drafted. That way, you've already planned for someone, and specifically who you want to make those decisions for you. You've already been able to select them, to appoint them So that way it's someone that you trust to carry out your wishes, as you've already stated that you wish for them to be carried out. Next is the advanced care plan. That's also what we call the living will. This document puts your wishes as to end of life care in writing. So it's similar in a way to the power of attorney for healthcare in that you're still appointing someone to make decisions for you when you can no longer make those decisions for yourself with regards to healthcare specifically. But instead of just making a blanket appointment of an individual to be your healthcare power of attorney, this advanced care plan or living will actually allows you the opportunity to specifically list your wishes regarding life support and other end of life care that you want. Some people don't care to have a living will drafted. Some people feel very strongly about it. With the one, preferred thing with the living will, some people have very strong opinions when it comes to life support or, artificial support. So, some people, for example, are very opinionated when it comes to, if they're in a coma with little or no chance to ever waking up, the doctors have said there will never be any improvement. Some people feel very strongly about whether or not they want to be put on life support at that point, whether they want the feeding tube to be administered and other end of life care to be provided. So this living will allows that individual basically to designate what they deem to be an acceptable quality of life and what treatment they would want to be provided if their quality of life was not acceptable to them. Similar to all the other documents that we've discussed already, it must be in writing, it must be signed, it must either be witnessed by two individuals or notarized. If my office does a living will, we notarize that document. And then it must be executed just like the other power of attorney. It must be executed while you are still competent. This is a kind of a snippet or snapshot of an advanced care plan or living will. You may have seen this document already, you may have not. As you'll see at the top, the box that is currently checked says, I give my agent permission to make healthcare decisions for me at any time, even if I have the capacity to make decisions for myself. Or you can do it to where this form only applies when you no longer have capacity. We've received some feedback. I said it on another conference or CLE with some physicians in the area that seem to really like this form just because of the simplistic nature of it. It's very straightforward. It's fairly easy to read in comparison to some of the 6 or 7 page living wills that you may have seen drafted at some point. So they seem to really like this document and the simplistic nature of it. The next box is that quality of life. So as you'll see on it, it says by marking yes below, I have indicated conditions I would be willing to live with if given adequate comfort, care, and pain management. By marking no below, I have indicated conditions I would not be willing to live with that to me would create an unacceptable quality of life. That right there is an important one. If I have a client that wants to execute this document specifically, we go over it in very, very thoroughly in much detail because I want them to fully understand what each box means, and what by checking whether it be yes or no, what that entails. So for example, the permanent unconscious condition, that's what I recently just mentioned, that I become totally unaware of people or surroundings with little chance of ever waking up from the coma. So for example, say the individual, executing this advanced care plan marked no on that box, then they would be saying, no, that is not an acceptable quality of life for me, or that's an unacceptable quality of life. The reason that first section, those first 4 provisions are so important is because if they mark yes to all of those, then you never even get to that next section of treatment. Because at that point, they're saying that all of these are acceptable. And at that point, where they want all treatment to be provided, because that next box of treatment only comes into play if their quality of life becomes unacceptable as indicated above and the condition is irreversible. So for example, on that first one, if they mark no to permanent unconscious condition, say they put no, that's not an acceptable quality of life. Well, then at that point, you would go down to the next box of treatment, say, okay, if your quality of life becomes unacceptable in that situation, if they're in a permanent unconscious condition, then they would mark what treatment do they want and what treatment do they not want. This is where I mentioned before that some people are very opinionated when it comes to CPR, life support, artificial support, feeding tubes, IV fluids, those sorts of measures or treatment. And so that is kind of just like a quick overview of that form. But like I said, that form I usually go over with them in much detail, and it's not a necessary form unless they want to specifically list out those provisions. Some people, instead of executing that advanced care plan, some people wish to just appoint a healthcare agent. And so in this case, they're not listing necessarily what they deem to be acceptable or unacceptable quality of life. They're merely appointing someone to serve as their healthcare agent or healthcare power of attorney. So that form allows them to designate the individual who they want to make medical decisions for them if they are unable to do so themselves. So, for example, that allows them to designate an agent to speak with doctors, other medical professions, or professionals about their treatment and about their care. And it also allows their designated agent to make sure that the directions in their advanced care plan are carried out if they had that advanced care plan executed. If not, and most of the time, if someone doesn't want to have that advanced care plan executed, it's generally, in my experience, it's because whoever they're appointing to serve as their healthcare agent or healthcare power of attorney, they fully trust that individual. They say that, we've already spoken about what I want, what I don't want. They know my wishes, and I fully trust them to carry out those wishes as, I've already discussed with them. And so, so in that case, they don't want that advanced care plan. They just want the appointment of a healthcare agent. Just like with all of the other documents that we've gone over, it must be in writing, it must be signed, it must be, again, either witnessed or notarized. If my office does a healthcare power of attorney or appointment of a healthcare agent, we always notarize it. And then it must be executed the same as the others while they are still competent, or while you are still competent, the individual who's executing that document. This is an example of a form fillable appointment of a healthcare agent. You may have seen this document. I believe it's available on somewhere on the state of Tennessee's website. I can't remember at this exact moment where this is available. But this is the one a lot of people will print this document off offline and fill it out. They'll list who they want as their agent. They'll list their alternate, and then they'll print, sign, and then you'll see block A that's down at the bottom. That is where the two witnesses can be. And as right above that block A, you'll see that it states to be legally valid, either block A or block B must be properly completed and signed. Block B is not, you can't see block B on this snapshot, but block B is where the notary would fill in their information and notarize the document. So just like, the advanced care plan, they can just have two witnesses to sign it. However, one big thing that I would caution, if you see one of these documents, make sure that their witnesses is not also the agent listed above, because that's not appropriate at all. It's kind of like when a will is executed, whoever is the witness, you need two two witnesses for a will execution, even if the document is notarized, but it needs to be a disinterested party. And that just means someone who can assess the competency of the individual executing the document, who's also, not benefiting from the document, which in this case would be, it's not an individual listed as the agent or an alternate agent. For the will, it would be, you don't want the individual who's listed as a beneficiary or executor, because at that point, they're not disinterested, they are interested. And the reason for that is if it's, someone who's listed in it, if it's an interested party that's witnessing a document instead of a disinterested party, it just opens up the door for allegations of undue influence, or abuse or fraud, to, having been committed. And so it's just, you want it to be where it's a disinterested individual, or competent adult that is witnessing these documents. To briefly touch on it, I do know, I've ran into this a couple of times now. I know that a lot of banks in the area are trying to kind of crack down on, and I'm glad that they're being more keenly aware of it, but when it comes to not necessarily the appointment of a healthcare agent, but the durable powers of attorney, which is, over the finances, they're becoming much more keenly aware of who's listed as that power of attorney for that individual, and what is their relation, what is their current living situation, and by living situation, I mean, what state does that power of attorney reside in? And, because they want to make sure they're trying to look out for the best interest of the individual who's appointing someone else as their power of attorney, but especially lately, in situations where it's an elderly individual, you might see someone come in, they're a neighbor, they've known this individual for, 2 weeks, and now all of a sudden they're becoming their power of attorney. That raises a lot of red flags. And I know lately banks have been, like I said, more keenly aware of that. My office, when we have an individual who wants to apply for any of these estate documents, we require that it be the individual who's wanting to execute the document. So, the individual who's wanting to have their will drafted, or the one who's wanting to appoint someone else as their power of attorney, we require that individual be the one who calls in to speak with our office. And that's just because we're trying to minimize any potential for abuse or undue influence. And that it's obvious that we get a lot of referrals from facilities and stuff, and that's kind of a different situation because, in those cases, we welcome those referrals. We want to help to execute these documents for individuals. But, when we get red flags is when we have the, and it's not necessarily that we won't execute the document, but we just try to we dive in a little deeper when, whether it be a niece or nephew or cousin or because a lot of times it is someone with a familial relation to the individual. If they call on that individual's behalf, and then then they're like, oh well, here I'll just give them the phone. That's not always in and of itself an issue, but it can be. If they're interrupting and not allowing the individual to speak for themselves. At that point, it just causes concern for us. Because we have to try to assess whether or not this individual is freely and voluntarily giving this power to their agent or power of attorney. So that's just like I said, just wanted to throw that part of it or that piece out there. And that is all that I have. Let's see, let me exit.
Thank you so much, Amanda. We do have a couple of questions.
Okay.
Had several people ask if you will share your PowerPoint.
Yes, I can.
Okay, if you will send that to me, or if we already have it, I'll just go ahead and share it.
Okay.
With everyone.
I can send it to you. I don't believe y'all have it already.
Okay. And then I had a question from someone else that said, is there someone that they can have a will prepared in Memphis, such as a walk-in clinic? Do you have any an answer for that, or?
For Memphis, they would need to contact, Memphis has their own legal aid. And so they would have to get in contact with Memphis specifically. I'm not sure. I know because of COVID right now in the pandemic, a lot of the legal aids have had to, kind of pull back on their ability to do those walk-in clinics just because of safety measures and stuff. But I can give you the contact information for Memphis Legal Aid, so that way they could reach out to them to see, if they do have a clinic. I know for my office right now, because of that issue, we have had the opportunity to go into some of the senior centers here recently to do estate documents, which has been excellent. But our Johnson City office, we do home visits. So if it's an individual who can't come to the office, especially in some of the really, really rural areas, just because of lack of transportation and stuff, we will actually go to them to do the document. So I don't know if Memphis does that too, but I know that my office does.
Okay, if you can send me that information from Memphis Legal Aid, then I'll pass it on to everyone else.
Okay.
The next question was, if you have a durable power of attorney, do you need to appoint a healthcare agent?
Yes, I would still appoint a healthcare agent. Most of the time we do both of those because, and it honestly, it depends on how the document's drafted because you can draft the durable power of attorney to where it covers both. So it's a durable power of attorney for finances, business affairs, property, and healthcare. You can pull them all into one, or you can execute both and cover all areas.
Okay, great. And I have another one. Do you use the 5 wishes? How is it implemented with the other documents you've discussed?
The 5 wishes. Can they elaborate on that a little bit? What they specifically mean by that?
Yeah, it's a document that you can kind of make your wishes known for healthcare and things like that. And it's just I think it's
So it's kind of like the advanced care plan.
so I think something like that. Maybe
Okay.
Gina's the one that gave the question. Maybe she can elaborate on that.
Okay.
So we'll give her a few minutes here to see.
Okay.
But that's all I have. I mean,
Okay.
I think it was an awesome presentation, and
Thank you.
I appreciate you doing that.
Oh yeah, of course. And I will say, while she's thinking about that, I will say that we do have a lot of times people will come in with wishes already, written down, and we write those in. So instead of using those forms that I showed, sometimes we do draft individually tailorized, healthcare powers of attorney or advanced care plans if they already have specific things written out that don't necessarily, meet the prongs of those canned documents. So that might answer her question.
Yeah, she said that it's a healthcare wishes document mostly used in end-of-life decisions.
Mm-hmm.
So
yeah, so that it sounds a lot like the advanced care plan.
right.
But yeah, if they had that, we a lot of times we'll include stuff like that when we're drafting those documents. So that way it all matches and you can kind of pull it all together.
Okay. That looks pretty much like all of the questions. I had one that said that they missed the presentation. Can they get the PowerPoint? So I'll send the PowerPoint to them. Yeah.
Mm-hmm.
Other than that, I don't think I have any other questions. So thank you so much, Amanda.
Yeah, thank y'all for having me.
Appreciate it. It was an awesome presentation, very good information. So I want to remind everybody to stay on the webinar for just a few minutes longer. There's a evaluation that we want you all to fill out. And also, this was done in place of our annual conference on aging, which we would have had this past April. But we are planning a in-person 2022 annual conference on aging, which will be on April 27th. So more information about that will follow. Let's just hope things with COVID calm down by then and we can have an in-person conference. But thank you again, Amanda, and I will get this information out to everybody once I receive it.
All right, thank
Thanks
you.
again. Have a good day.
You too. Bye.